against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. Okay. On January 5th, 2025, the officer was conducting surveillance as part of a traffic crimes task force of motor vehicles racing westbound on Grand Parkway, and the officer observed the defendant's vehicle traveling in lane 2 and another vehicle in lane 1. The motor vehicle slowed down to approximately 30 miles per hour before launching at the same time in a competitive manner, accelerating to well over 110 to 125 miles per hour in an attempt to outpace each other. The motor vehicles raced 3 times, then pulled into a Buc-ee's. The officer observed the defendant, but was unable to locate the other motor vehicle involved in the race.
So then it says that also he picked up a felony evading. He was on bond for a felony evading, and now he's picked up this case, a racing?
It looks like that's the case, Your Honor. He was on bond for the evading.
I'm taking away your privilege to drive. You are not allowed to drive, Mr. Lee. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This is an affidavit that you're going to promise me that you're not going to drive. Do you understand? Yeah. There's a burning building with 50 kids in it. I don't care. Do not drive. You mind filing those conditions as well, please? No driving.
No driving. Yes, Judge.
You have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Johnson. He will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, you pick up another case, I'm going to revoke it. And if I find that you're a danger to the public, I'm going to make it sky high. I will do everything in my power to protect my public at all costs. Do you understand? Do you want the same day as the felony? Yeah? Okay. All right, guys. I'm going to have you sign a reset. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. All right. Thanks, guys.
The felony is all the way in June 2nd.
2026, Your Honor.
Is it set for trial or something?
No, he was on that's a placeholder setting because it was a PTI.
What's going to happen with that? Is he still in the PTI?
It was, from my understanding, I don't know. I think it was some conditions he had to do and he's almost done with it. So I think this is close. I don't know.
So is that, do you know whether they're going to keep him in now? Do they know about this?
I'm sure they know, but
does the felony court?
I'm not attorney.
You're not the lawyer.
No, but they.
Okay. So let's just do this. Let's just do it right. We'll do a 30-day reset. And then I don't know what's going to happen upstairs. We'll see. You just keep us in the loop. Okay. All right. Good to see you.
Good to see you.
Next judge is page 10. Pace, come on up.
Good morning, Ms. Pace. Ma'am, you were charged with driving on a suspended license. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do a probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 2nd, 2025, the officer observed the defendant's vehicle at the 900 block of Burke Road. He ran the license plate and had a return of an expired registration as of November 2024. A traffic stop was conducted, and the defendant was not able to provide a Texas driver's license, so instead the defendant provided a name and date of birth. The defendant stated she did not have financial responsibility on the vehicle, and the defendant...
Right out the gate, this is standard Miranda plus arraignment structure. But notice how quickly the court moves into probable cause. The real question, does the state actually have clean, articulable facts, or just assumptions?
Was shown to have a suspended driver's license not eligible with multiple Class C warrants.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case.
Can I say something?
Please don't. You have the right to remain silent. Exercise that right. Do you have the ability to hire a lawyer?
Yes, I do.
You don't want a court-appointed lawyer?
No, I don't.
Okay, so we'll give you time to go hire a lawyer. I am making it a condition of your bond that you're not to drive unless you have a valid Texas driver license and liability insurance. And I'm going to have you sign a promise with me today. Doesn't matter what's going on in your life. If you want to drive, go get a license, get liability insurance. If you can show me that, I'll take this restriction off. Happily. Okay? you? No. Just okay, man. So I'll have you sign this reset. I'll have you get with Victoria for a reset, and we'll get you out of here, man. Okay? Thank you.
All right, Judge, next is page 11. Reyes, come on up.
Good morning, Mr. Reyes. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 2nd, 2025, the officer was riding with HPD Traffic Crimes Task Force, and a group of vehicles was meeting at 430 West Parker Road in Harris County, Texas. The officer observed the defendant, who was 18, brandish a firearm while walking around his vehicle. And the defendant exited from the motor vehicle on the driver's side, walked around the motor vehicle while brandishing the handgun, and then sat in the front passenger side seat. A traffic stop was initiated, and the officer made contact with the defendant, the passenger of the vehicle, and the defendant admitted to carrying around a handgun, which was found under the passenger seat in the motor vehicle where the defendant was sitting.
Mr. Reyes, I'm going to find that there's probable cause to go forward with the case. What are you doing with yourself these days? Are you in school? You graduated from high school? Okay. I'm ordering you as a condition of your bond not to be in possession of weapons. You are not allowed to have a weapon. Do you understand? If I find that you have a weapon, you pick up a new case, I'm going to revoke your bond. I will put you in jail. Do you understand? Tell me, you want a lawyer? You don't want a court-appointed one? You do one? Okay. I just fill out an application. Let me see if I have an application on file. I need you to fill out an application for me. Let me take a look at it, and then I'll appoint you one here in a bit. All right? Come on. Do you mind, Ms. Brown, giving him an application?
All right, Judge, next arraignment is page 13.
Can you
Scott,
file?
come on up. Counsel, do you have an arraignment?
No, approaching for bond violation.
All right, we're doing the.
Bear with me. I think we're close. Are you Mr. Scott? Mr. Scott, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can.
This is the core of the entire racing allegation: speed, coordination, and intent. But here's the legal tension. Without the second vehicle, how strong is the competitive racing narrative really in court?
Will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, in Harris County, Texas, the officer was dispatched to an assault. The officer met with the complainant, who stated that the defendant and her had been in a sexual relationship, and she confronted the defendant about sleeping with another woman. The defendant became angry and followed her to a gas station, where he pushed her to the ground with both hands, causing pain.
Okay, Mr. Scott, I'm going to find that there's probable cause to go forward with your case. Do we know, have you spoken to her to find out what she wants? Does she want to have contact with him? Does she not want to have contact with him?
Your Honor, we have not reached out at this time.
Okay.
Well, Judge,
Hold on a second. Just don't say anything at this point. I've got a bunch of DAs here. Whatever you say, they can use against you. I can give you a lawyer today if you want one. You know, you can give your side to the lawyer. The lawyers can talk to the DAs, but I don't want you to say anything to make the case any worse. All right. Because I don't know what she wants, I'm ordering you not to have any contact with her, not to be in possession of any weapons. I'm also entering what's called a magistrate order for emergency protection that identifies Ms. Walton as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate any threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Judge, you know the property that she knows I paid for and proved out on the state and allowed me to get the homeless rights.
Let's do this. Let me give you a lawyer today. I can have them reach out to find out where she lives, what the address is. I just don't want you to have contact with her. I don't want you to go where she lives or where she works. That's it. Okay? I don't know. Let's do this. Let me give you a lawyer and we'll go from there. Okay? Do not leave until you sign our bond conditions, though. Sorry?
Thanks for respecting now my kids of your ability to improve the court nights and not
So hang tight with me. We'll help you out. Don't worry. Okay? Please.
All right, Judge. Next
Yeah, I want to
is
do them all.
page 5.
This is Scott.
Gutierrez, Angel.
Top of page 13. Can you, hey, no contact weapons.
Last one for now. Counsel, you can't come
So that was the last one.
for now.
No Spanish?
No.
Wow. Okay. Hi.
Aaron Durden.
Okay. Come up, Mr. Durden.
Mr. Durden was placed on bond conditions in November, toward the end of November, got it interlocked at the end of November. It's very first date to go have it recalibrated was 12/29. He was out of town on that date, didn't get back until the next week, was locked out. I got an email on Monday from the control officer saying that he was locked out and notified you as well. He went the very next day, got it fixed, but you asked us to come here today to address it. He now understands.
I'm not going to play this game with you. Court orders are court orders. You have to follow them. And when you don't, there's severe consequence. And the consequence is you end up in jail. So I'm going to give you a pass now. But if it continues to happen, it's just not going to go well for you. Do you understand?
Yes, sir.
Okay. All right. That's it.
Is there a date that we have to still on? Thank you. I'll do that.
That line isn't just dramatic. It's judicial boundary setting at maximum intensity. The judge is making it crystal clear. Public safety conditions override emotional hypotheticals. No exceptions.
You ready? Hi. Who do you have?
Mr. Kabir, K-A-V-I-R. Who's here for a bond violation because of a lockout, Your Honor? He's since remedied that. Apparently his power battery
Do
shuts
you
off.
mind bringing him up?
Unconditional, yeah.
Nothing.
Between them and the state, you know.
I'm not going to play this game with you, Mr. Kabir. If this continues to happen, it shows me that you're just don't care about the bond conditions and their severe consequences. Do you understand?
Your Honor, I don't drive this
I'm
vehicle.
I don't want you to, I'm just telling you, I have bond conditions in place and I expect for you to live up to them. And when you don't, there are severe consequences. Do you understand? Okay. Did you guys didn't want to add anything? Or did you have something to add? No?
No, Your Honor. No, that was the only reading.
Okay. All right, man.
All right. Thank you.
Okay, bear with me. We'll do it.
Judge, that was continued supervision?
Yeah. Hi.
I was just gonna ask if you could sign something in your queue for Juarez Chavez.
Yes.
Oh, great, sorry, thanks. Sorry.
Just kidding.
She wanted us to know.
Hey, I don't have it. I don't have it.
May I approach? I'm here on an arraignment. My client, Barragan, B.A.
I'm ready when you are. Do you mind bringing them up? Good morning, Mr. Barragan. You were charged with racing on a highway. You were facing up to a year in jail. Up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 5th, 2025, the officer was part of a street racing and takeover task force and was advised of a group that met at a gas station parking lot in the city limits of Harris County, Texas. The officer was working in a plainclothes capacity and was following the group from one location to another and viewed two vehicles race side by side at Highway 290 and Kickapoo Road, traveling westbound. The officer observed the defendant's vehicle and another vehicle slow down to approximately 50 miles per hour before launching at the same time in a competitive manner, accelerating well over 100 miles per hour in an attempt to outpace one another. The officer maintained visual and was able to detain the defendant, the driver of the silver Nissan observed, but was unable.
This is where probable cause shifts from traffic enforcement to weapons and narcotics territory. Once marijuana plus firearm enter the same narrative, bond conditions and legal exposure escalate instantly.
To locate the other vehicle.
How fast are we talking? Over 100?
Let me see if he specified, if it was just that. The officer only said well over 100. He didn't specify.
Paragon, I'm ordering you as a condition of your bond not to participate in this kind of activity again. If I find that you're racing, if I find that you participate in any kind of street takeovers, anything of this nature, reckless driving, donuts, whatever, I will take your ability to drive away from you. Do you understand? Not only that, it is a condition of your bond, and if I find that you do, I can revoke your bond and put you in jail. Can you file those conditions, please?
Yes, Judge.
You're going to reset your case to give you time to fight this thing. I'm going to have you sign a reset, Victoria. I'm going to have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then after that, you'll be free to go. You have a lawyer. Because you do, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you she can't get a hold of you because you're playing games, you pick up a new case, you've become a danger to my community, I will put you in jail. Do you understand? Okay, come on. Thank you.
Judge, I didn't hear, so PC was found, were there state's bond,
States conditions, yeah.
state's bond condition?
Yeah.
Okay, got it. Also, there was one more, sorry, off-docket arraignment that was probation consent of the year. So whenever you're ready, I'm ready.
Okay, who is it?
It's a turnout up there, last name Worthy.
Emmanuel Worthy, come up.
Sorry.
Did you get the cause number for this?
Yes, Judge.
He's on probation. Has a motion been filed? I don't know, because the bond's still set at $100, so I don't know if a motion's been filed. Mr. Worthy, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 8th, 2025, the officer responded to a DPS agent who stated he was following the defendant's vehicle and needed assistance on the traffic stop, as the DPS agent was conducting surveillance on an unrelated case. The DPS agent provided a description of the defendant's vehicle, and the officer observed the defendant's vehicle failing to signal a lane change, along with the defendant's third brake light being out. The traffic stop was then conducted, and the officer made contact with the defendant. The officer observed a strong odor of marijuana, and the defendant was asked to step out of the vehicle, and the defendant stated there was nothing illegal inside. The officer located a cigar filled with a green leafy substance known to be marijuana based on training experience with a weight of 0.09 grams or 0.032 ounces. A PC search of the vehicle was conducted, and the officer located an unholstered black handgun inside a backpack in the back seat of the vehicle.
This is the defense's pivot point, possession versus proximity. In multi-occupant vehicle cases, that distinction can completely change whether charges stick or collapse under reasonable doubt.
Mr. Worthy, I'm going to find that there's probable cause to go forward with the case. Take a seat for me in the jury box. Okay, come on.
Good morning, Judge.
Hey.
Judge, I have a quick question. I have Jonathan Guidry Joyal popped up on my docket. The only issue, I would like to hear PC, the only issue is he's in processing. I don't know if you want to wait till he pops up, or can we hear PC?
Yeah, we can hear PC, of course.
Yes, Judge.
You don't think there's PC?
I think there's two main issues that I'd like to treat you with.
It's under jail. Oh, get unlawful camera. Okay, go ahead.
Yes, Judge. On January 8th, 2025, the officer observed the defendant's motor vehicle fail to signal for 100 feet prior to making a lane change twice from lane 3 to 2 and then from lane 2 to 1 on East Tex Freeway in Harris County, Texas. A traffic stop was initiated and the officer observed further movements between the occupants of the vehicle before the driver, defendant Price, age 19, rolled down the windows of the motor vehicle. The officer approached the motor vehicle and observed a clear plastic bag with green liquid in plain view in the driver handle, believed to be promethazine based on training experience, and a bag with marijuana in the driver door pocket. The weight of the marijuana was 0.82 grams, and the promethazine was 101 grams. The officer observed an AR pistol in plain view on the rear left floorboard or left rear passenger seat, where the defendant, Guidry Royale, was seated. Guidry Royale, age 19, and a PC search on the motor vehicle was conducted, and the officer observed another AR pistol inside a black backpack in the right rear passenger seat where the defendant Kinnan was seated, along with defendant Kinnan's cell phone. The officer observed an unholstered Glock in plain view adjacent to the first AR pistol on the floorboard behind the driver's seat. The defendant, Guidry Royale, stated the firearms were passed from the front to the rear of the motor vehicle, but would not state who handed him the firearms.
If I may, Judge, hear the issue. So some stuff that's not there is that they were looking at this vehicle beforehand. This is
Remember, this is a probable cause hearing. I mean, I can't get into, like,
correct.
you know.
It's a suppression team. They're looking, they're following. It's a contextual stop. They're following them, waiting for a reason to stop them. The reason that they give is didn't signal for 100 feet. Sounds like they're on the highway. Okay. That's a conclusory statement. They're not stating that anybody else was in danger. They make no mention of.
Well, failing to signal a lane change is a good, I mean, it's a traffic violation, is it not?
Well, 100 feet. They don't say at what point he failed to signal, whether or not he signaled at all, whether or not he signaled under 100 feet. They don't state at what foot or feet he did signal. It's conclusory. They don't give articulable facts regarding that. And so because it's conclusory and we don't.
I don't know. I think that there's enough probable cause to go.
Here's the second issue, Judge. The second issue is in the DIMS, this officer is stating that my client says they passed the gun to him and they handed the gun to him. That's what the DIMS says. But the OR says that my client says he doesn't know who tossed them from the front to the back. He doesn't say they handed it to him. He doesn't say they passed it to him.
But there was also an AR on the floorboard where he's sitting. Right?
He says that they're not his. There's 4 people in the car. There's 4 people in the car. And only 3 out of 4 get charged with an unlawful carry.
Now we're in full extradition risk territory. Judges don't just see the charge, they see geography as risk. Out-of-state warrants instantly transform bond into a flight risk calculation.
Variable weapon. He doesn't say, hey, they handed it to me. Hey, they passed it to me. What he says specifically is doesn't know who tossed them from the front to the back. This correlates to the furtive movements that the officer is talking about. He never claims possession of these guns. The guns are all in the car. He says they're not his. Says the guns are not his. But he gets charged for the ECW.
And we're supposed to just take it, then just believe his right?
Your Honor, if I may, and that's why, because they were found in the area where he was seated, the AR pistol, and he is underage at the time. That's the reason why he was charged, because he had them in his immediate proximity in the vehical.
Yeah, I think that there's enough. Sorry?
It would be a question of fact, Judge.
Okay.
I think that there's enough, sorry.
Okay. Understood, Judge. Thank you, Judge.
Thank you, Ricardo. Mr. Doyle, you ready? Mr. Kim? Hello. Happy Friday.
Happy Friday.
Happy Friday.
I'm here on Mr. Reader.
Reader. Yep.
He's finally here today.
Do you mind bringing him up? What's new? Everything all good?
Just, kicking off the new year. Kid stuff. How about you?
Same thing. My life revolves around kids,
My son still won't wear long pants, he'll still wear shorts.
In this weather? Are you?
That's a thing.
My daughter wears them fine, but yeah, my son just refuses.
How old is he?
He's 8, so.
It's 8.
Just doesn't care. He'll freeze to death before he admits.
Hopefully he's wearing a jacket and a sweater.
Looks comical. Yeah.
I love shorts as well, and I hate wearing pants too, so.
That was after.
Are you opposed?
So I'm not opposed to a bond, I'm just opposed to a low bond. And so council has shared some more information regarding, because we haven't been getting, it's another one of those, we can't get a hold of the people from the demanding jurisdiction. It's one of those because it's a 2B warrant, it hasn't been assigned to a prosecutor yet. And so we were trying to get a hold of the actual investigator for this charge. And Amy and I got shuffled around a little bit, so we could only speak with the extradition investigator, but we couldn't speak with the original investigator. So my facts are very, very limited. We don't.
I'm happy to give you some background, Judge. Mr. Reader, military veteran, was a medic in the Pacific, in Korea, meritorious awards, done well. When he finished with the military, the Army, lived in Georgia, then was hired over here by a very reputable hospital and medical center. He's the lead administrator. He was referred to me by the chief neurologist of this hospital. What ends up happening, he is in a custody dispute, and I believe Judge Kirby's, is that the judge, over in family court?
Here or over there?
Here. As this custody dispute sort of soured for his future ex-wife, he shows up at his hospital to go to work and is sworn and arrested on a warrant that he had no idea about. Apparently, this is some allegation that occurred in Georgia in June of 23. No report was made at the time. I think the state will confirm that. It wasn't until the custody issue here started to go south for his future ex. She then makes an online report in DeKalb County, Georgia, to accept charges without ever even talking to him, getting his side of the story. There's actual video evidence, I'm told, of what happened that's been litigated in family court. They're not responding to the state. All we want is a low bond so he can go deal with this there. He's not a flight risk. He's not family here. He's obviously got a good job. His boss is the one who brought me in on this. And so, I don't want to ask for a dollar bond, but I ask as low as the court wants to go because it is a cash bond, and he's going to have to go hire a lawyer to deal with this.
So you're not going to go represent him over there?
I'm not. Well, I'm going to get it. I know. I stay in my lane.
Got it.
We're going to find somebody in DeKalb County that will make this go away.
So, Mr. Reader, you are wanted out of the state of Georgia for aggravated assault and cruelty to a child. What we have here is, I don't know you. I've never met you before, but my main concern are two. Are you a danger to my community? And number two, most importantly, are you going to go back to Georgia? I have to make the bond sufficiently high if I give you a bond so that you're going to go back, because you are, as everyone, it's an inherent flight risk because you're a fugitive from another state.
Judge, if I could, one other thing. The aggravated assault, my understanding in Georgia, is the impeding breath statute here, and the child part of it is
the allegation is the 12-year-old child witnessed this. So it's not, there's no weapon involved or anything like that. It's a simple domestic violence situation.
Any prior criminal history?
No, he has no other history, Judge. And so I'm not able to confirm, but that seems logical in terms of when the warrant was dropped, but it is correct. The charges, the Texas equivalent would be impeding breath, and I guess, I don't even know if we have.
You don't know this with certainty that
Oh,
that's
no, for the
what,
charges it is, but for the date, I don't have any other information. Like I said,
I don't know the actual, what the facts, what.
yes, the strength,
Eating breath, or whether it's shooting a gun.
And then it's strangulation, and the cruelty to child is the fact that the 12-year-old witnessed him allegedly strangling his wife. So, but regarding that, because of the nature of the charge, it's that state requests a $10,000 bond. And so.
You're okay with the bond?
With a bond being set, because he has no prior other criminal history, he hasn't exhibited any other information I could find that he's a flight risk, so.
Okay. So state wants a $10,000 bond. What's your counter?
My counter would be 1,000, Judge. He's not going anywhere. He's got a good job here. He's got support here. I'm here. They're not bringing me here to run away from anything. We're going to go fight this case and clear his name. Everything's here.
You got to understand that, if I set you a bond, we expect you to follow through, and there are very serious consequences. You're old enough to know that actions have serious consequences, and if you fail to act, I'm going to set you a bond, and we give you 14 days from the date of your release to go turn yourself into Georgia. If you fail to do that, I'm telling you now, I'm not going to play this game with you again. If you fail to go, I will issue a nationwide warrant for your arrest, and I'm going to set your bond at 0. You won't get another one. Do you understand?
Yes, Your Honor.
I don't know. So he wants 10, you want 1,000. I'll set it at 5,
Would you consider 2,500? Because my understanding, it's a cash bond. So we have to pay, we can't get a bondsman in here, pay the 10%, and he's going to need money.
I'll defer to the court. Sorry, I was working on the waiver withdrawal form because he waived the magistrate court, so I'm just working on the waiver withdrawal right now. But I defer to the court. Because he doesn't have any other history, and because I'm limited information, it's hard for me to make any further assertions because no one's getting back to me.
Credit, they've gone out of their way to reach out to Georgia, and they're not responding. It's not
he's great.
Lack of diligence on their part. Apparently, DeKalb County doesn't find this as much of a priority to respond to them, and they've had 2 days while he's been sitting in jail.
Okay, we asked you the 2,500.
Thank you.
Moment, I have one form. You just sign one form. Give me like 5 minutes.
The only other thing that I'm going to counsel you is that you got to be careful, man. What you do impacts everyone around you, especially a child. Hell hath no fury like a woman scorned and a teenager out of control, because the teenagers that's out of control can make your life a living hell. And when they see that kind of, it impacts everyone. And I'm telling you, it reverberates, and it can just, like an infection, just grow out of control. 90% of the people in there now, no self-control. They get upset, they wig out, and they just go without thinking, hey, if I do this, what's going to happen? If I say this, what's going to happen? Patience really goes a long way, All right, I'll set the bond at 2,500. Just be careful, man. All right? Okay, Mr. Doyle.
Thank you, Your Honor.
Thank you, Judge.
Excuse.
Yes, sir.